Cruel and Unusual, The American Death Penalty and the Founders' Eighth Amendment by John D. Bessler is a comprehensive, scholarly, and deeply moral investigation into the historical, legal, and philosophical contradictions surrounding capital punishment in the United States. Through meticulous research, Bessler argues that the modern practice of the death penalty is fundamentally incompatible with the original intent behind the U.S. Constitution's Eighth Amendment, which prohibits cruel and unusual punishments. The book dismantles the conventional narrative that the death penalty was intended by the founders to remain a permanent fixture of American justice, showing instead that many were deeply skeptical of its necessity and humanity, even in the 18th century. Bessler opens by immersing the reader in Enlightenment thought, which heavily influenced the American founders. Thinkers like Cesare Beccaria, whose seminal treatise on crimes and punishments argued forcefully against the death penalty, had a profound impact on men like Thomas Jefferson and Benjamin Rush. Beccaria believed that the state had no right to take a life and that capital punishment was neither a deterrent nor a morally justified form of retribution. Bessler carefully traces how these Enlightenment ideals informed early American debates on punishment, especially within the context of a fledgling republic attempting to distance itself from the brutal spectacles of European monarchies. Central to Bessler's thesis is the idea that the Eighth Amendment was crafted during a time of growing reformist momentum, when corporal and capital punishments were increasingly seen as barbaric remnants of the past. He explores how the word unusual in the Eighth Amendment was deliberately chosen not just to address arbitrary punishments but to open the door for evolving standards of decency. In this sense, Bessler makes the case that the founders intended the Constitution to adapt over time, in keeping with human progress and moral development, especially in the realm of criminal justice. Throughout the book, Bessler focuses on the historical shift in how societies think about punishment. He examines colonial-era executions in graphic detail, highlighting the public spectacles of hanging, whipping, and dismemberment that served not as deterrents but as tools of state domination. The U.S. inherited this brutal legacy but also carried the seeds of reform. As Bessler shows, early American states experimented with alternatives to execution, including penitentiaries and labor. These were considered more humane and more consistent with the Republican values of rehabilitation, proportionality, and the rule of law. In weaving legal history with cultural and moral philosophy, Bessler scrutinizes how American courts and legislatures moved through cycles of expanding and restricting capital punishment. He details how, despite recurring moratoriums and Supreme Court rulings questioning its fairness, the death penalty keeps re-emerging, often bolstered by political pressures, racial bias, and sensationalist media. His legal analysis is precise, and he challenges the often cited assumption that the Constitution offers permanent license for executions. Instead, he argues, it invites each generation to assess what is now deemed cruel and unusual. One of the most powerful elements of Bessler's argument is his focus on human dignity. He places this principle at the core of the Eighth Amendment's meaning, arguing that any system of punishment that fails to respect the inherent dignity of individuals runs afoul of constitutional protections. From this standpoint, Bessler critiques not only the physical brutality of executions, such as botched lethal injections, but the psychological torment of death row, decades of isolation, uncertainty, and humiliation. He describes how the death penalty system has become a sprawling, inefficient bureaucracy that delivers arbitrary outcomes and false promises of justice. Bessler also emphasizes how racial injustice is baked into the American death penalty. He shows that from slavery through Jim Crow to the present, executions have disproportionately affected people of color, particularly black men. He draws attention to the racial disparities in sentencing, jury composition, prosecutorial behavior, and the historical use of capital punishment as a tool of racial terror. These systemic inequities, he argues, are not aberrations but are intrinsic to the operation of capital punishment in the U.S., rendering the entire practice unconstitutional under equal protection principles as well as the Eighth Amendment. The book doesn't just critique, it offers a vision for reform grounded in both constitutional tradition and global human rights standards. Bessler notes that the U.S. is increasingly out of step with the rest of the democratic world, as most countries have abolished the death penalty and consider it a violation of fundamental rights. He urges a return to the founders' Enlightenment principles, not out of nostalgia, but because those principles call for a justice system rooted in reason, compassion, and the capacity for moral growth. In discussing recent Supreme Court cases, Bessler expresses concern over the court's often narrow and inconsistent interpretation of cruel and unusual. He argues that the judicial system has sometimes treated the phrase as static and literal, rather than dynamic and contextual. This approach ignores both the historical flexibility intended by the founders and the brutal realities of how the death penalty is administered today. By failing to grapple with this reality, the legal system perpetuates a punishment that is demonstrably unfair, often irreversible, and increasingly condemned by international norms. The depth of historical documentation in the book is impressive. Bessler pulls from colonial records, trial transcripts, legislative debates, and constitutional conventions to reconstruct a more nuanced picture of the founders' views. He doesn't portray them as abolitionists in the modern sense, but as reform-minded thinkers whose commitment to rational, humane governance would likely make them uncomfortable with today's death penalty, especially given its documented flaws and injustices. What makes Cruel and Unusual particularly resonant is how it links past to present. It is not merely an academic study of what Jefferson or Madison thought, but a living argument about how those foundational values should inform modern policy. Bessler is deeply concerned with how America defines justice, and how clinging to archaic forms of punishment undermines both legal integrity and national character. In the end, Bessler's work is a powerful call to conscience. It challenges readers to examine not just whether capital punishment is effective or popular, but whether it is just. In doing so, he brings the conversation back to first principles. That government derives its legitimacy from its moral authority, and that true justice is measured not by retribution, but by humanity. Through rigorous argument and historical insight, Cruel and Unusual presents a compelling case that it is time for the U.S. to finally abolish the death penalty, in keeping with both its constitutional ideals and its evolving moral responsibilities.